in today's video, I have some incredible news for undocumented spouses of U.S. citizens. Hey everyone, U.S. immigration lawyer Michael Ashoori here. The Department of Homeland Security has recently announced a new policy will essentially pave a pathway for undocumented spouses of U.S. citizens to get lawful permanent residence in the United States and eventually be on the path to obtain U.S. citizenship. I'm very excited to go through the details of this new update in today's video, so make sure to stick around. We're going to discuss a new policy put forth by the Department of Homeland Security that is essentially titled Parole in Place. So this is a policy that's going to be helping the undocumented spouses of U.S. citizens, specifically people that came into the United States without inspection. So somebody can enter the United States with a visa, and that's considered an entry with inspection. Or perhaps if somebody entered without inspection, that would be the alternative. Now, I want to provide a little bit of background regarding what the issue is here and what problem is being solved so that we have some background. And then I'm going to give a bit of an overview regarding the policy that's been announced by the Department of Homeland Security. And we're also going to go into a detailed presentation where I'm going to cover what the requirements are to qualify for this new parole in place and various questions that you might have regarding this. So a lot of information to cover, but I'm very excited to jump right in. So first and foremost, earlier I discussed that there are two different categories. There's one category is if you enter the United States with a visa. And another category is if you entered the United States without inspection and you basically had an unlawful entry in the United States. If you entered the United States with a visa, and even if you overstayed that visa, but you're in a lawful marriage, a bona fide marriage with a U.S. citizen, then the immigration laws allow for you in many cases to get a green card in the United States by applying from within the United States through a process called an adjustment of status. So many people that entered the United States with a visa, let's say they entered as a visitor or they entered on some non-immigrant visa like an H-1B work visa or something like that. And let's say they overstayed that visa. In many cases, assuming these individuals are eligible, if they are in a bona fide marriage to a U.S. citizen, they can complete the green card process from within the United States through a process called an adjustment of status. Now, what about the other category of people? If somebody entered the United States without inspection and they were to get married to a U.S. citizen, based on the immigration policies prior to this announcement, that spouse that is now married to a U.S. citizen could not complete the marriage-based green card process from within the United States. They could commence the process within the United States by filing a Form I-130, which is the immigrant petition that's filed with USCIS to demonstrate that there is a bona fide marriage and to demonstrate the relationship is there. But individuals that entered the United States without inspection could not do the second part of that process, which is the adjustment of status. The adjustment of status is the process of going from whatever status that the individual currently is in, adjusting to lawful permanent residence, a green card. They could not complete that process from within the United States. Instead, they had to depart the United States and apply for an immigrant visa at a consulate outside of the United States. Now, here's the issue. If an individual enters the United States without inspection, for one major issue is that all of that time spent in the United States is considered unlawful presence. And based on accruing a certain amount of unlawful presence in the United States, you could become subject to a bar from re-entering the U.S. Depending on the length of that amount of unlawful presence, you could either be subject to a 3-year bar or potentially even a 10-year bar, among other issues. So the issue is that, let's say somebody entered the United States without inspection and they get married to a U.S. citizen, and now they have to go abroad to complete this process, but leaving the United States and then seeking a visa, well, they would now be subject in many cases to a bar based on the unlawful presence accrued in the United States. Now, under the current laws, there are in certain cases a waiver that the spouse can apply for to overcome that unlawful presence bar, that can overcome that 3 or 10-year bar that the individual needs to wait to lapse before they can re-enter the United States. So there's a waiver available in certain cases. However, the waiver process can be extremely time consuming. And on top of that, it's not 100% foolproof solution. Somebody can get a waiver approved and still potentially face difficulties in securing their immigrant visa abroad. So it's very time consuming and to some extent, it's risky. And who's to say that a waiver is even going to be approved in the first place? The waiver itself is based on there being an extreme hardship to your U.S. citizen spouse. So that needs to be proven as well. So there's a lot of issues with the current policies in place for undocumented spouses of U.S. citizens to obtain their green card versus somebody that entered with inspection, entered with a visa, and just so happened to overstay that visa, where they could relatively simply apply for their green card from within the United States through the adjustment of status process. So now this brings me to the update that I'm sharing with you in today's video, which is that the Department of Homeland Security has announced a parole in place policy. Basically, what this policy is going to do is that for certain spouses of U.S. citizens that are undocumented, and in certain cases for their undocumented children, the Department of Homeland Security has announced that assuming these individuals meet certain qualifications, they can apply for parole from within the United States. Now, here's the big news. If somebody through this program is granted parole through this new parole in place policy, then they will be now considered to have become inspected and paroled in the United States. What this means is that following the approval of that parole, they are now in position to apply for employment authorization to legally work in the United States, and assuming the various eligibility criteria are met, they are now eligible to apply for an adjustment of status in the United States to basically get their green card from within the United States, similar to the group of people that we talked about earlier that entered with inspection but just so happened to overstay their visa. Now, through this parole in place policy, this group of people that entered the United States without inspection, assuming they are approved for their parole, they get their parole granted and the various eligibility criteria are met. Also, similar to people that overstayed a visa, they can now apply to adjust their status within the United States without having to go through that whole burdensome process of leaving the United States, facing those risks associated with seeking a visa at a consulate abroad, having to apply for a waiver, and in many cases wait several years to get that waiver approved, and all those hurdles that had to be done based on the laws in existence prior to the implementation of this new parole in place. So I know there's a lot of details here and it's a lot of information to digest, but ultimately this is very positive news for undocumented spouses of U.S. citizens and their children that are also undocumented. So now that we've covered some background information and kind of conducted a bit of an overview of this news, I want to go over a short presentation that I prepared to cover some important points, such as what are the requirements to qualify for this process, what does the application process look like, and various other questions that you might have. So let's get into that right now. So here's our presentation on the parole in place policy explained. So let's get started. So as an overview, the Department of Homeland Security has announced a major update to the immigration system for undocumented spouses of U.S. citizens and their children in some cases. DHS, the Department of Homeland Security, will establish a new process to consider on a case-by-case basis requests for parole. If someone that qualifies is paroled, a qualifying undocumented spouse can apply for lawful permanent residence from within the U.S. through adjustment of status without having to leave the U.S. and get an approved waiver, which is that whole process that we talked about in the introduction that can be both time-consuming, costly, and can have various risks associated with it. This has the potential to help approximately 500,000 spouses of U.S. citizens and 50,000 non-citizen children. Okay, so now we're going to get to this aspect of the whole parole in place program that many are interested in, which is, of course, how do you qualify for this? Well, to be considered on a case-by-case basis for a discretionary grant of parole in place under this process, an individual must, and these requirements that we're outlining here are for the spouses. In the next slide, we're going to cover stepchildren. On this slide, we're going to cover spouses. So you must be present in the U.S. without admission or parole. So again, this is not for somebody that entered with a visa and overstayed their visa. This is for somebody that is in the United States without admission or parole. And you must have been continuously present in the U.S. for at least 10 years as of June 17, 2024. You must also have a legally valid marriage to a U.S. citizen as of June 17, 2024. Additionally, you must not have disqualifying criminal history or otherwise constitute a threat to national security or public safety. And additionally, you should otherwise merit a favorable exercise of discretion. Now, here's how stepchildren can qualify. To be considered on a case-by-case basis for a discretionary grant of parole in place under this process, an undocumented stepchild must be physically present in the U.S. as of June 17, 2024, and must have a qualifying stepchild relationship to a U.S. citizen as of June 17, 2024. And as some background information on how the immigration regulations deal with stepchildren, to qualify as a stepchild under the immigration regulations, the non-citizen child must be unmarried, must be under the age of 21, and the marriage of their parent and the U.S. citizen, step-parent, must have taken place prior to the child's 18th birthday. Now that we've covered the requirements to be eligible to apply, now we're going to cover how to apply. Well, speaking generally, you're going to need to file a form with USCIS and include supporting documentation with that form demonstrating that you satisfy the requirements and the qualifications, and you're likely going to have to pay a fee. Now, the information that's currently available regarding the application process is very limited. Further information regarding eligibility and the application process will be published in the near future. Now, this is very important because people are understandably very excited about this, and people might want to just begin sending applications using whatever information they have available and just try to get an early application in. But USCIS has made clear that they will reject any filings or individual requests in relation to this process received before the date when the application process begins later this summer. Now, after the application is submitted, and of course, we're anticipating this updated information regarding the application process. But once USCIS receives a properly filed parole in place request, USCIS will determine on a case-by-case basis whether a grant of parole is warranted. So that's some general information on how to apply. Now I want to get into some questions that you might have. How should I prepare for parole in place? Well, the first thing is that you should await the additional information that's going to be forthcoming regarding when applications will start to be accepted and what forms are going to be needed to apply for parole in place. So that's step one, is being on the lookout for this updated information. Step two is to begin compiling certain evidence that you have available to demonstrate that you've been continuously present in the United States for at least 10 years as of June 17th, 2024. And you also want to begin to compile the evidence of your legal marriage to a U.S. citizen as of June 17th, 2024. Now, what are the fees for this process, you might be wondering? As of right now, the information on the fees, potential fee waivers, the forms that are going to be required have not yet been released. So this is still something that we're awaiting. Now, this is another question. I entered the U.S. with a visa and overstayed. Am I eligible for this parole in place program? The answer is no. This new parole in place policy is available for those that entered without inspection. If you entered with a visa and overstayed, you may wish to check your eligibility to do an adjustment of status, because as we mentioned in the intro to this video, there are ways for somebody that entered with a visa and overstayed to complete their adjustment of status from within the United States based on their bona fide marriage to a U.S. citizen, and that is separate from this parole in place program. Now, lastly, if I am granted parole, will I be eligible for employment authorization? And the answer is yes, and the specifics on the application process for employment authorization, more information on this should become available shortly. Most likely, in order to apply for the employment authorization, you're going to file a Form I-765 application for employment authorization. So there you have it. In this video, we covered this new parole in place policy that's been announced by the Department of Homeland Security. Again, it's tremendously exciting news for the undocumented spouses of U.S. citizens and their undocumented children. While we don't have all the details of this policy yet, We expect that further details will be announced shortly. I hope you found this video helpful. I hope you found this video valuable and you learned a lot from this video. If you know anybody that can benefit from this information, please feel free to share this video. We're all about empowering you with knowledge, so the more people that can benefit from this information, the better. As always, if you like this video, please make sure to smash that thumbs up button so that YouTube knows to share this information with more people. If you have any questions, feel free to put them in the comments below. As always, thank you so much for tuning in, and I'll see you on the next video.